Hello, everybody. I'm Amani. I'm a graduate student in Texas A&M. So it is my pleasure to welcome you to the 2017 NAPB webinar series themed Building Better Plants for the 21st Century, Updates and Upgrades in High Throughput Phenotyping, Intellectual Property, and DNA. Each year, the National Association of Plant Breeders organizes and sponsors a series of educational webinars. If you are a professional working in plant breeding, these webinars offer an opportunity to learn about new ideas, develop new skills, and stay current with changing technologies. For undergraduate or graduate students in plant breeding, this is a chance to broaden your current learning and applied skill level. Our speaker for today is Dr. James R. Myers, Professor of Vegetable Breeding and Genetics in the Department of Horticulture at Oregon State University. Dr. Myers holds the Baggett-Fraser Endowed Chair of Vegetable Breeding and Genetics in the Department of Horticulture, where he breeds half-dozen vegetable crops. His main interests have been to improve vegetables and field crop varieties for disease resistance, human nutrition, and organic production systems. He teaches a graduate course on intellectual property as applied to plant improvement at OSU. His talk today is titled Trends in Intellectual Property Protection in Plant Breeding. Welcome, Dr. Myers.
Thank you very much. Let me share my screen here and we'll get this going. Okay. Thank you, Amani, for that introduction. Today's subject is one that is, it's about an area that's really in a state of flux for plant breeding, and as a result, there's some controversy. New patent law continues to be made and litigated. The codification and application of intellectual property to crop plants has been ongoing almost as long as we've had formal plant breeding programs, certainly from the early 20th century. And I'm basing my remarks on over 30 years of experience as a plant breeder in the public sector, initially working with dry beans, and then the last 20 years have been in the vegetable realm. When I started out as a graduate school student, plant variety protection was a relatively new thing, but it was only just a couple of years later that utility patents in the claim of living organisms. I would also preface my remarks by saying that what I've learned about intellectual property protection has been primarily self-taught. It's, I think we all, as plant breeders, are exposed to some degree to intellectual property as practicing breeders and in the varieties that we're working with. But there have been certain utility patents that have affected my breeding efforts directly, and that was the motivation to dig much deeper into this and learn quite a bit more about this area. And then for the past decade or so, I've been teaching about intellectual property, which helps keep me current. What I'm going to focus on today, I think, is just to get everybody on the same page, forms of intellectual property protection, with the main focus being on plant variety protection, utility patents, and licenses, examples of patents that affected my research. What are current trends in intellectual property protection over time? And then I want to spend some time talking about licenses and how they're applied in conjunction with other forms of IP. And then new initiatives to facilitate germplasm sharing. The other thing I would say is that in these sorts of talks, I'm not a lawyer. I'm not dispensing legal advice, and so don't take it in that way. These are the personal opinions of a public plant breeder. Basically, patents and intellectual property protection has been around. It's been legislated by the government as a means of encouraging innovation in various areas, technological pursuits. Basically, the government assigns a 20-year monopoly to the inventor for the commercialization of the invention, and in exchange requires disclosure of that invention so that that technology, others can take that technology and then innovate on that technology. The forms of intellectual property protection that are available in the United States, which will, by the way, be the primary focus of my talk. I'll stay pretty much out of the international arena. But the forms are plant patents, which were first developed in 1930. These apply primarily to asexually propagated crops, with the exception of edible tubers. This plant patents are administered by the U.S. Patent and Trademark Office, which administers utility patents. Plant variety protection, which is under the auspices of USDA Agricultural Marketing Service, was implemented in 1970. There have been a couple of revisions on it to keep it in compliance with some of the international patent law, the most recent of those being 1994. And then utility patents. Utility patents have been around since the founding of this country. The first utility patent was granted in 1790. But for up until 1980 was not applied to living organisms. And it was the case of Diamond versus Chakrabarty in 1980 that Chakrabarty worked for General Electric, had a microorganism that was good, that he had created. It was a genetically engineered organism that was good at cleaning up petroleum, and his company wanted a patent on that. And the patent was denied. They took it through the court system, and in 1980, the Supreme Court ruled that patenting living organisms, as long as they had been altered by the hand of man, was allowed. In 1985, the USPTO extended that concept to plants through ex parte hybrid. That's an internal decision-making process that they used there. And this was challenged by Gem Ag Supply, and the basic idea there being that patents, that the Congress had created plant variety protection as a means for protecting plants, not utility patents. That was not found to be the case. The Supreme Court ruled that utility patents do apply to plants. So those are the major decisions and leave us where we are today. There have been some other decisions about things like patent exhaustion and patenting naturally occurring gene sequences that are still ongoing nowadays. The trend has been towards increasing control of access to seed. In addition to to patents and plant variety protection, F1 hybrids can be regarded as a form of protecting intellectual property through trade secret. You maintain the inbreds as a trade secret, and your competitors cannot reproduce your F1 hybrid. Cytoplasmic male sterility in some forms may be a way to access or restrict access to traits, particularly in crops where there are no restorer genes. It's very difficult if there's, say, a disease resistance in a cytoplasmic male sterile background. It'd be very difficult to get it back out of that background and into fertile material unless you have fertility restorers. Then there are licenses. This is kind of the new wrinkle of what people are applying in conjunction with other forms of IP protection. There are technology use licenses and bag tag licenses. These are all based on contract law. So looking at a comparison of plant variety protection versus utility patent, if we look at breeder's exemption, this exists in plant variety protection. This allows a breeder of another entity, or not the owner of the variety, to use that variety in crosses and create new varieties. This exemption does not exist in utility patent, and it could be written into a utility patent, but I have never seen it done so. Essentially derived is whether a variety is very closely related to another one, say a back cross or something like that. PVP does not allow essentially derived, whereas utility patent would allow that sort of thing to happen. Farmer's exemption, it is generally allowed under PVP. Farmer may save seed for personal use in a quantity similar to what they planted before. Utility patent, this sort of exemption does not exist, and I've never seen it written into a utility patent. The scope on PVP is cultivars only, whereas with utility patent, it can be quite broad. It can include cultivars, it include technologies, it can include methodology as well, or some combination thereof. The requirements for PVP are that the cultivar be distinct, uniform, and stable, whereas with a utility patent, the requirements for a technology are that they be novel, useful, non-obvious, and that there be no prior art. The expense for the two, PVP is somewhere in the neighborhood of $7,000 to $8,000 nowadays. Utility patent can be tens of thousands of dollars, and invariably involves lawyers writing the patent, whereas PVP is often the breeder writing the material, and then maybe a tech transfer or a lawyer prosecuting it. So in exchange for this 20-year monopoly and this public description, these are some of the perspectives that the private sector has on utility patents instead of PVP versus perspectives from the public sector, kind of the dialogue that is currently going on. Utility patents are very strong in their protection, very absolute, whereas from the private sector perspective, PVP is rather weak. The breeder's exemption can be an issue, and the farmer's exemption as well. Let's say that I'm a private breeder and I have spent 20 years developing this unique package that is superior to anything out there in the market. I don't want to put it out there and have my competitors take that and in just a few years have those same traits in their material, which often can happen. There's also the use of broad patents and utility patents. These are ones that either cover enabling traits or they cover more than one cultivar at a time. These can help reduce patenting costs because you can release cultivars that are a group of cultivars at once rather than one by one at a time. From the public perspective, the major concerns are that it prevents access to germplasm, particularly the elite germplasm. Sure, you can get lines out of the plant introduction collection, but they often don't have the suite of traits that you're really interested in. It can lead to a slowing of innovation and genetic progress, and I'll have more to say about that later on. There's less communication among researchers, and part of this has to do with the first to file option with utility patents. You don't want to talk about your work if someone else might file before you do. A reluctance to engage in some research areas where there are patents. It's just not, what's the joy of working on something if someone else owns it? Broad patents on traits can lock up an area as well, similar type of idea. And then the trend of increasing intellectual property, I think, has led to increased barriers to international exchange of germplasm. There's certainly a lot more red tape that we have to go through to exchange germplasm, and in some cases, countries have completely embargoed germplasm coming out of their country to developed countries. I'd talk about some patents that have affected my research directly. There's the Enola, or the yellow dry bean. There's a Nunya bean patent. I'll spend most of my time on those. There's also a patent on exerted stem broccoli, which, if you go to this link in the Virginia Quarterly, you can review. You can find an article called Linux for Lettuce, which describes the broccoli situation. And then I'll mention tomato flavonoids, and each of these I think has kind of a lesson or as to how to deal with these. The Enola patent was on beans, a color of beans, basically. Peruano, azufrado, or Marcova beans are something that have been around for centuries. They were introduced from Peru into Sinaloa, Mexico in the mid-20th century, and there were breeding programs there that were breeding these. With Hispanic migration into the U.S. from Sinaloa, there was demand for Peruanos, so there developed this cross-border trade with bringing varieties in. These varieties they can be grown in the U.S., but they lack some of the disease resistances that we need for good production here. In the early 90s, an individual from Redbeard Bean went to Mexico, purchased a cello pack of these beans, and came back, grew them out, selected a couple of years among plants, and came up with a stable variety. And then he applied for a utility patent on these, with the primarily the main claim being the distinct color of these beans. And what this was enforced with custom agents with Munzel color charts at the U.S. border, turning back shipments of these beans from Mexico, giving Redbeard the monopoly on the production of this type of bean in the U.S. In 2004, Paul Gepp's group at University of California, Davis, conducted a genetic study, and they showed that Enola was basically identical to a variety developed in Mexico called Peruano 87. And with this information, USPTO revisited these claims, and in 2007 they invalidated the critical claims in the patent. Basically, there was a 12-year delay in others being able to innovate with these types of beans. I first was starting to work with these in 1995, put the project on the shelf during the years that the patent was in force, and then continued after the claims were invalidated. And in 2016, we released a new yellow bean variety called Patron. Popping beans. This is another example of a broad patent. Popping beans are a kind of bean that come out of the high Andes. They are day length sensitive, so they don't grow well here in the U.S. The unique trait that they have is they cook very quickly with a dry heat. And some people in the U.S. were seeing potential utility as a snack food or for rapid processing of dry beans. There were actually two patents applied for on popping beans. One was on the beans themselves, and the other was on their use. And the first patent basically claimed the integration of the popping ability trait into day-length insensitive background so that they could be grown in the U.S. These were very broad claims. They claimed any North American dry bean market class as the recipient. They claimed all the Nunya accessions that are housed in the plant introduction collection. They had very broad claims in terms of description of growth habit and maturities and things like that. The Inland's Empire Foods was the company that contracted with a university breeder to develop these lines. This patent was challenged by CIAT, the International Center for Bean Research, but it was upheld by USPTO. This patent was eventually abandoned for not paying maintenance fees, and this happened. Just an aside here: maintenance fees are something that are required of utility patents at 4, 8, and 12 years. You have to the inventor has to pay an escalating fee to maintain the patent, and it's designed to keep patents from just being placed on the shelf. But initially, the maintenance fee was not paid at the 8-year mark in 2010, but then a waiver was applied for and obtained, and the late fee was paid. Then in 2014, the maintenance fee was not paid, and so the patent became abandoned. Again, a 12-year delay. Now there is a germplasm out of Colorado State University that's been released, other programs that are working with these beans. And then the final case, I guess what I would say is both of these bean patents are examples of very broad patents. These still happen today. They're not very frequent, but occasionally they do and affect large areas of research. High anthocyanin fruit tomatoes. This is an area that I have worked in since becoming a vegetable breeder. Basically, we were interested in putting anthocyanins into tomatoes and increasing their levels. And we were, out of this work, the expression in much of the material was very low, but we discovered ways to increase it. So we get very dramatic expression, and Indigo Rose was one of the first varieties developed out of this. We published on this work initially in 2003, and then on combining these traits in 2008. I had grad students producing theses on this. And in particular, there was a patent that was published. It never was granted, but it was looking at this, combining a gene called high pigment with anthocyanin fruit to intensify pigment. And this is something we had explored in my grad student's thesis and work, which made it prior art. And so ultimately this patent was abandoned, and I think it was because of this, the prior art that the examiner found. But at the same time, while this was happening, there was a great deal of uncertainty as to what was going to happen with the tomatoes that I had released. Oh, and here's a picture of what the combination of anthocyanin fruit with high pigment looks like. So maybe this is a good point to stop and to answer any questions that people might have.
No questions at this time, Jim.
Okay, well, I will keep going. We'll talk about patent trends here. This is a graph we did. I've gone into the various databases and looked at trends over time with patents. This is a graph showing utility patents from 1985 to present, and a number of documents per year that are filed and obtain priority. This is the red and blue lines. When they publish, which is the green line, and then when they are granted, which is the yellow line, and then when they expire. You can see that over time there has been an increase in the use of utility patents over time. It fluctuates quite a bit, going up and down, maybe because there are few players who are doing this, which means that they may file a lot in one year, but not so many in the next year. I'm not sure. At the very end, I'm ignoring this, the 2017 data, because I don't think we can draw many conclusions from what's happening right now. But it does look like maybe now there's a decrease happening, a drop, but I don't know. It'll probably take several years before we see whether that trend is real or not. With plant variety protection, this is the trends we see. I've split this out so that you can see public patents versus private patents. Again, there's this general increase. There's some fluctuation, particularly within the private sector. There seems to be a decrease going on in the use of plant variety protection in recent years, whereas there's just kind of a steady increase with the public sector using plant variety protection. One thing to note is that the overall number of patents or certificates or applications that are made for PVP are lower than for utility patents. We're at about applications filings are at about over 1,000 per year, and for utility patents, but the peak here has been at about almost 600 per year for PVP. This table looks at some of the different vegetable crops and where the patents lie. And I would, it's kind of a mixed bag. For some things, there are very few patents that are applied for, with onion, for example. I would split these out into cultivar patents that are based just on the cultivar, patents that are based on, say, a cultivar that has a particular trait, and then I've split out those that I consider to be particularly broad. And it's very unequal in which crops are using what. Lettuce seems to be one where there are a lot of patents being applied for cultivars. Now, some of these crops, also there's some trait patents, some of these of which are fairly broad in lettuce. The other two crops where there seem to be quite a bit of use of trait patents are peppers and tomatoes, where I think primarily in conjunction with disease resistance. If we look at, if we compare, here we have vegetable crops with a couple of field crops, field corn and soybean, you can see that, and I should say that in the field crop, soybean and field corn are the drivers of the major use of patents. And you can see this very steep increase in the use of utility patents in the 2000s. But there does appear to be a definite drop in recent years for both soybean and field corn in these. The use of utility patents for common bean, which includes both garden bean and dry bean, has generally been fairly low, kind of fluctuating, but there does seem to be an increase in lettuce, and we'll look at these in a little more detail in a minute. Here's a comparison of utility patents with PVP. You can see it shows that there is this dramatic increase in use of soybean and field corn utility patents compared to PVP, and definitely a drop-off in the use, primarily for field corn in recent years, in the use of PVP, maybe kind of flat for soybean. For vegetable crops, these would, lettuce and tomato would, well, lettuce is really the one where they're used primarily. I chose common bean as an example of another self-pollinated crop besides lettuce, and then tomato as a hybrid crop. And here what we see is the same dramatic increase in the use of utility patents for lettuce, a similar increase for tomatoes, but on a much lower scale. And then beans just kind of fluctuating. Hard to say what's happening there. If we compare PVP and utility patents for lettuce, you see that a definite decrease in the use of utility PV for lettuce, and with this increase for utility patents. And then, as I mentioned, bean just seems to be all over the map, with a comparable use of utility patents and PVP for beans. For tomatoes, what really surprised me about tomatoes is very few forms of intellectual property protection are used for tomatoes, and maybe people consider F1 hybrids to be the main form that are used. But generally, very little use of PVP. There's been this increase in use of utility patents for tomatoes. The entities that are applying for patents are primarily in the private sector, and many of the same ones for both PVP and utility patents: Monsanto, Pioneer, Syngenta, Limagran, Harris Moran, and Limagran. And I'm including Seminis with Monsanto, DuPont with Pioneer, and then the other thing that did surprise me with PVP in particular is that there are several universities public programs that have a relative, they make it into the top 10 group as in number of PPPs that they have in their portfolio. Not so much the case with utility patents. Again, it's primarily the private sector. There are a number I classify just as other who may have just a handful of patents. Many companies that fall into that category. University patents, there are no individual universities that make it into the top group with utility patents. I've lumped all these together, and you can see that it's a relatively small number of utility patents that come out of universities. So just to summarize, there's definitely been an increase in the use of utility patents, mainly by the private sector, with a concomitant decrease in the use of PVP by the private sector. There may be a dip happening in just the last few years in the use of utility patents. I don't know if there's a real trend or not. My take home in the vegetable sector is that utility patent use is highest in some of the self-pollinated crops like lettuce and the high-value crops like lettuce, where there's not a possibility of making F1 hybrids. Beans seems to be kind of an exception to this, but maybe it's the low value of the crop relative to something like lettuce. Okay, this would be, I think, another good breakpoint if people have questions.
Yeah, Colin says, where do the numbers for the PVP and utility parent data shown on the graphs come from?
The data from these, some of this comes directly out of the U.S. Patent and Trademark Office database. Some of it, the PVP data comes from a file that is posted on the USDA website that lists all the plant variety protection certificates that have been applied for or issued. And then some of this data comes from a private program, which I forget the name of, which our tech transfer for people have. The first graph that I showed comes from that source, and where I sat down with some of our tech transfer people and they ran some of these queries. So that's where the data comes from.
Okay. All right. No more questions at this time.
Okay. Well, let's move on to licenses then. Licenses, as I mentioned, are generally used in conjunction with other forms of IP, usually with PVP or utility patents or plant patents. Very rarely, there are some cases where people use standalone licenses, but this is not commonly used. There are also technology use licenses, which are mainly applied to genetically engineered crops and are mainly concerned with the genetically engineered trait that the crop possesses. Then there are bag tag licenses, which are being applied very, very broadly. These are similar to the shrink wrap or the click-through licenses that we see on software. And then the other thing that I want to talk about in terms of license is Open Seed Source Initiative, which is a form of open source license. So this table here is similar to one I showed you earlier, but I've included a column for licenses. Licenses are generally, they don't specifically have a reader's exemption. I've never seen one written in a license. In fact, usually they're written like a utility patent to exclude breeders' exemptions and farmers' exemptions. They don't address essentially derived, so in theory, a license could be applied to an essentially derived variety. They can be very broad in scope. They're very flexible as to how they're written. They basically have to meet requirements of contract law. And one of the consequences of these is that I think what we're seeing is we're moving seed from being something that can be owned under PVP to something that is rented by a farmer under utility patents and licenses. And this is a trend generally with in software and in with various technologies, apart from crops and seed plants as well. Time limit is basically determined by the licensor. Licenses are often written for 5 or 10 years, or they may be written for the length of the term of other IP. Expense, it usually requires an involvement of a lawyer to write a license, so there's going to be some expense involved, but it may not be as great as applying for a utility patent. So why not use licenses as the sole means of IP? After all, they'd be cheaper, potentially more flexible. They're mainly the main issue with them is that not all potential parties may be included in a license. The licensor may intend to apply to all, but if an individual receives that seed but doesn't receive the license with the seed, then they may not be bound to the terms of that license. And so then why at least licenses are usually used in conjunction with other forms of IP that provide a robust legal basis for challenges. So here's an example of a bag tag license from a seed company, and you have the image on the right, and then what is written. What you see on the back of a packet of seed, and what we've seen for many years, is usually a warranty and a limitation of liability, and an indemnification clause, a notice of arbitration. It's been in the relatively recent times that there are use restrictions that have been added to these as well. So basically, this says, by opening this container, you agree, and this license has 3 parts: not to save any seeds or plant parts, to prohibit selection of material from the field by third parties, and not to use any of the material for breeding, research, seed production, reverse engineering, molecular or genetic analysis. So that basically excludes using that variety for doing variety trials. Here's a license from a different seed company that makes this explicit. This is their bold on the statement: the seed should not be used for research, including but not limited to agronomic comparisons and yield testing. So these are very limiting licenses, I think, in terms of what can be done with the material. And in my view, these are what's called in contract law unconscionable terms, because they're either very onerous or they're not really enforceable. The license that I just showed you came on a packet of seed that was sent to me by the seed company in response to a letter that I had sent requesting entries for trial, for doing variety trials. So the company was violating its own terms of license by supplying the seed to me. Another effect that this is having is that we cannot, if we can't material, then we can't really have an unbiased evaluation of different varieties in variety trials. And the other thing I would say is that, the license is on the packet that comes from the wholesaler, and if it goes to a retailer who then repackets the seed to sell to home gardeners and fresh market people, that license is not necessarily conveyed to the end user, who have not agreed to the terms of the license and then are not bound by the terms of that license. So those terms on that license may not be enforceable, or they're at least only unevenly enforceable. So what all these things are leading to, I think, is that we, there's limited sharing of germplasm, and I think this has a limitation on the genetic advance within crops. Certainly the potential to. 2 graphs here. just kind of hypothetical things where these numbers represent different companies or different entities, public sector programs perhaps, and then these lines represent the progress in trait improvement over time. And in an open germplasm sharing system, where someone might innovate, then others will get that material pretty quickly, and they'll incorporate those innovations. So you generally see this fairly even wavefront moving along over time. And a system with IP constraints, and in particular, we're talking about a 20-year lag time, in the most serious situation, then there will be innovators. Each company will have its own pile of germplasm which they will work with, but the sharing between won't really happen, and so there will be an overall lag time in the overall trait improvement in that particular crop. The companies are certainly aware of this, and there are some recent responses which I think are very interesting. These are primarily happening in the private sector between companies. There is the International Licensing Platform for Vegetable Breeding, which includes 10 major seed companies, and they represent about 50% of the vegetable seed trade. Syngenta and Simonis are not part of this, but it's a platform for licensing varieties for among to use for continued breeding. Then there is as both Syngenta and Simonis have their own platforms. The Syngenta has tradability platform, and then Simonis has a licensing platform under Monsanto for doing this. What I don't know is how well this system works in terms of private sector, public sector exchanges. Many public sector breeders make their material available through material transfer agreements to the private sector. There's not so much material coming back the other direction. Then the other thing I would mention is that takes kind of a diametrically opposed view to all this is Open Seed Source Initiative, or OSSI, which is dedicated to open source access to plant genetic resources. And basically, it boils down to the OSSI pledge. You have the freedom to use these OSSI pledge seeds in any way you choose. In return, you pledge not to restrict others' use of these seeds or their derivatives by patents or other means, and to include this pledge with any transfer of these seeds or their derivatives. So the seeds and their derivatives are kept in the public sector. I think some in the private sector are not happy to see this, because then this creates a pool of germplasm which is they consider off limits to their own activities. The other thing is that it does not really allow collection of royalties, or the compensation coming back to breeders is somewhat problematic, I think, under OSSI. And most companies who are involved in this are fairly small and selling directly, and obtain their revenues then coming back from directly to them through their programs. So there are so far 373 cultivars, 56 crops, 38 breeders who participate from 41 companies in OSSI. Something very interesting, I think, to watch as we move forward in the future. Now, there have been some interesting things happening in Europe with changes to utility patent law. Before 2015, you could not patent cultivars in Europe. You could only patent traits or kind of broad technology ideas. But that changed in 2015, where the regulatory agency said that would be allowed. Some countries within the EU have said this will be allowed. but then there was a initially put forward by Plantum, which is an umbrella organization of commercial seed companies in the Netherlands, to put a breeder's exemption in European patent law, and also to develop a database that would allow breeders to determine what has been patented so they could avoid infringing. And this has come to pass. The database is called Pinto, and you can see the link for it right here. And then 4 countries now have breeding exemptions in their patent laws, that being France, Germany, Switzerland, and the Netherlands. One new wrinkle in this, though, is that it does require licensing. Once something has been released, commercialized, then it does require that there be some compensation going back to the originator of that germplasm. So when patents are first issued in a new area, utility patents can be overly broad. I think there's a need to provide examiners with access to prior art and with the knowledge of the research community. I would like to see that made available. Perhaps a pool of research community who could assist patent examiners through non-disclosure agreements, for example. Another thing that I think I would like to see changed would be that the use of, or the ability to claim germplasm in the public domain and utility patents should not be allowed. I don't know whether this would be something that would be stated within, say, the National Plant Germplasm material system or materials, but that's, I don't think, a valid use of public germplasm. Some of the things that I have learned over the years, and just in particular, if you're in an area and you're not intending to apply for utility patents, then make sure that you publish your research as frequently as you can and as broadly as you can, in as much detail as you can, and communicate about this. This establishes prior art then that will prevent patents in areas. Prevent broad patents primarily. You can comment to patent examiners when a patent application, there's a fee charged for this, and there's a limited window of time when you can do this. But you should get on Google Patents and set up the email system to send you notification of when patents publish in your area of interest. Another thing that I've found is that sometimes patent attorneys prosecuting a patent will have to come back to you to as the originator of some germplasm that's subject of this patent to obtain that germplasm or details, and that is an opportunity to provide prior art to the attorney prosecuting the patent. And they are legally obligated then to share that information with their client and with the patent examiner. So that's where I will leave it, and I thank you all for listening to what I had to say.
All right, no specific questions at this time. Ann made a comment in Q&A, and I think others should be able to see that. If someone, maybe the attendees will let me know if you can see Ann's comment. I think she's got some good information there, but I think it's a little too lengthy to actually read out off, so we won't do that at this time. And Ann, if you can copy that into chat, I don't want you to retype all that. If you can copy that into chat so others can see it, please do so. So yeah, we've got about 10 minutes left, so we'll hang around and allow people to ask questions. No questions at this time, though. So I'll prime the pump. This is not my area, so this is probably a stupid question, but I'll, since there's no other questions out there, I'll propose it, Jim. Is that how easy is it to reverse engineer plants, products, to vegetables. You know, I'm thinking about the bean example you used. If there are qualities that are there, people like you and others who really know what they're doing, can you really go in and either genetically process or do other things to essentially reverse engineer a vegetable or fruit?
Well, yeah, there are various techniques that you can do something like that, I think. I guess reverse engineer can be the idea of understanding what went into making that material, and certainly with techniques like genome sequencing, we can do that today. We can also take traits that are unique or of interest and then use backcross to put them into new backgrounds. But the other aspect of that question, come up with something that's exactly the same as a cultivar that may have been patented, and that would be very difficult to do given the number of genes that are involved in living organisms. So that's I think that gets to the basis also of cultivar patents. What are the claims that these are based on? One is that they are novel, that every cultivar differs from every other cultivar in some manner, and that's a case that has to be made to the patent examiner.
Yeah, I mean, a big part of bringing anything to market is testing the market to see if it's viable or not. And so one could argue that, you know, if you're sitting back and you watch a fruit or vegetable come to the market that becomes popular, and even if you don't clone that, even if you come up with your own variety of it, you know, have you sort of stolen someone else's thunder or market share by doing that? And so I would think from a legal standpoint that wouldn't have much weight, but I guess you never know.
Mm-hmm.
Okay.
Yeah.
Okay, Marie, let's get some questions from attendees. Marie asks, let me scroll up here. So public gardeners like to select and use their own seed should concentrate on varieties which patents of prohibition do not exist anymore. I'm not sure if that's a question or that's just maybe a statement based on what I was saying. Go ahead, Jim.
Yes. Well, that's, it's certainly varieties that are protected by utility patents and with licenses are off limits to saving your own seed at this point in time. That's up until the patent expires at 20 years or so. The real difficulty is knowing what the status of intellectual property protection is on a particular variety. So it may be that it's PVP, and in which case there would not be a problem with saving your own seed. But if that PVP was put out with a license, then that license may affect your ability to save seed. So those are some of the considerations that you have.
Okay. Janice says, do you think that consolidation in the industry is having an effect on the number of intellectual property rights applications being filed?
That's an interesting question. I think if there were more companies out there, there might be even more patents, utility patents in particular. But the biggest players are the main drivers of utility patents, and in PVP, main users of intellectual property in particular. I really don't know what the relationship between consolidation and trends in patents are at this point in time. That might be an interesting one to delve into as a research question.
Yeah, I mean, just my experience being in the software development realm, and we went through this in, I guess, the early 2000s, is you did have consolidation of technologies, and big software companies, they had the resources to have teams of lawyers who could bring lawsuits and make claims, and so that was certainly a part of the equation.
Mm-hmm. Yeah, certainly having deep pockets is an important part of being able to use utility patents.
Sure. Louisa says, how do you see the impact of trademarks on germplasm exchange and innovation in plant breeding?
Okay, trademarks. This is another can of worms that we haven't even opened today. But what trademarks are being used more and more as kind of a branding, and it can be a barrier to well, just to how something is named. Trademarks are basically on a name and as establishing a brand. And what the trend is nowadays, for example, with things that go through PVP, is that you release them. You obtain your PVP under the experimental number, and then apply for a trademark name for that particular variety, or for varieties that might be sold under that trademark name. And so the thing about a trademark is that it's not necessarily specific to one variety. It may be that more than one variety may be used. I think an example that I heard about recently was the cuties in cutie citrus is sold in grocery stores here in the U.S. and it may not be the same cultivar that is used every time in that particular brand or that sold under that trademark. I don't see trademarks as a substantial barrier to release of varieties and to sharing of germplasm. I guess that's the bottom line for me here.
Okay. Craig says, why the concentration only on PVP and utility? Why have you not discussed plant patents, which are also very important, but for the clonal propagated crops except potato?
The main reason for that is that's not my area of expertise. I have never written a plant patent or worked in that area. I have some knowledge of them and how they're applied. I think they tend to be less controversial, although there is one area of controversy currently in plant patent law, and that concerns the use of material under plant patent for making crosses and further breeding. Basically, plant patent law says there's one claim, and it basically claims that cultivar, and it only applies to the asexual propagation of that cultivar. So it's been understood for many years that breeders can take material like that, make a cross with it, and then develop a new variety to release under a plant patent, for example, from that material. But that is being challenged in recent years. That some entities are making the claim that you cannot use something under plant patent, held under a plant patent, for sexual reproduction and for crossing and etc. So that'll be an area to watch in the near future with plant patents.
All righty, we're coming up on the top of the hour, so we only got a minute or so left. Jody says, in cotton we had an example where we had germplasm that was published and released as a germplasm along with SSR markers for the trait of interest that Monsanto successfully patented, and then the researchers could not use their own lines. Do you have any suggestions on how to protect against this?
Well, I would have to know the details in a case like that, and what the terms of, or what the claims were in the patent that Monsanto received for that. That's the devil's in the details with these things, and claims can be so specific that they might cover things that were not addressed in the original germplasm release and the documentation of that material. So I hesitate to really try to comment. I guess my only advice on that would be to try to anticipate what would happen with patenting that material and writing your release notice or communicating about the variety in a way that covers that anticipates the claims that would be made for that material. That's about the best I could tell you.
Alana I think that was a comment about trademarking. She says see TMEP, which is Trademark Manual of Examining Procedure 1202.12 for more information on trademarking plants. So I think folks can see the question and answer. So I'll let folks grab that information from there. We'll do one more question, then we'll close. Mohammed says, is there any DNA fingerprinting of DNA barcoding? Yeah. Is there any DNA fingerprinting of DNA barcoding system being used anywhere to register and patent granting of crop varieties, specifically OPs or hybrids?
I know that fingerprinting is being used in PVP applications, in some cases to make to meet the claims of distinctness under that claim. Where say fingerprinting or where molecular tools might be used with utility patents tend to be in the trait patents or the more broad patents, where they might claim a cultivar along with a trait, and then they describe that trait in molecular terms and the markers that are used for that trait. Let's say if it's a quantitative trait locus or a discrete locus, markers may be part of the application. It's with both OPs and F1 hybrids under PVP, those fingerprinting is something that is used, and it probably will become more common in the future, particularly with publication of genome sequences for many of our crops.
All righty, great, Dr. Myers. Thank you so much. This was great, but we are out of time, so we'll stop now. Again, just a reminder, folks, this is being recorded. It'll be available at the Learn event at learn.extension.org within a few days. So feel free to share it with friends or colleagues that might not have been able to attend. And also, plug for our final webinar in this series. Amani just put a link in chat there for that. It's going to be May 10th at 2 p.m. Eastern Time, 10 p.m. Central, and there's a link to the Learn event in chat for that. So with that being said, Dr. Myers, any closing thoughts?
Well, this is, like I said at the beginning, a very dynamic area, and I would say stay tuned for new and interesting things happening in plants.
All righty, thanks everyone so much, and we'll see you again soon. Bye-bye.
Bye-bye. Thank you.
Bye.